Thank you.
All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number 1, CACR 19-0513, State of Arizona versus Sean Douglas Cameron. Counsel, remind you that the oral argument is being recorded, and so I'd ask you to please identify yourselves and who you represent at the beginning of your arguments. Each of you will have 20 minutes in which to present your arguments, and appellant's counsel, if you'll watch the clock and reserve as much time as you need for or desire for rebuttal. Also, please keep in mind that we've read the briefs and have discussed the case this morning in conference. I would also mention is that it may feel a little awkward, but would actually prefer that you remain seated because the ability to pick it up in the microphone will be a lot better. I know this is, unique times, so if you don't mind just staying seated for your arguments, that will be helpful. With that, counsel for appellant, you may proceed.
Good morning, Your Honors. I'm Kathy Brody. I'm with Lee Stein here on behalf of appellant Sean Cameron. In a criminal case where the only direct evidence is an accusation and a denial, any additional evidence has much more power to sway the jury. And this was just that kind of case. In particular, the evidence that Sean physically abused his son and that DCS removed his son from the home for that reason was incredibly prejudicial. How could the jury not hold that against Sean? His daughter was accusing him of long-term sexual abuse. The evidence that he physically abused his son allowed jurors to think he was a horrible parent and a chronic abuser of his children. In other words, if he keeps getting accused of abuse, he must be an abuser and he must be guilty.
I'll be candid, I'm very concerned that line of questioning went too far and was error, but given the record in this case and the evidence of 12 years of sexual abuse of a female child, how can we say that that's not harmless error?
That's a good question. Here, again, with the only direct evidence being the accusation and the denial, it just tips the balance in favor of against Sean in a way that is unfair. And Your Honor, all of the cases, Terrazas, Anthony, they all talk about how harmful other acts evidence could be. And in a case like this, again, that was just the only direct evidence. How could it not?
Are you suggesting that the balance was really close and that the jury might have simply disbelieved that all this occurred but for this one excerpt from the testimony?
I mean, it was a credibility contest, Your Honor. Anything like that. And when you look at Anthony, for instance, the court talks quite a bit there about how other acts evidence can be so harmful. And even if you have a strong case against the defendant, and even if you have a limiting instruction, which here there was not, but in Anthony there was, this type of evidence can still be harmful to the extent that you cannot find beyond a reasonable doubt that this was harmless. And in this,
what was the defense theory at that point in the case? Was it that this was all a pack of lies and that his sort of emotional text about affection and everything was just taken out of context and none of this ever happened? Is that the theory?
Essentially, Your Honor, and that's that's what the defendant testified to, that this never happened. The theory of the defense was that the daughter came forward with her allegations as a result of being upset about some discipline that was imposed by her father. And I would say, Your Honor, if you look at the reason that this evidence is so harmful is because it would never meet those requirements of Rule 404B. On the one hand, it doesn't meet that invited error doctrine, and then on the other hand, it can't meet those requirements of 404B.
Some of it could have reached the invited error doctrine, right? Because if you look at the transcript, and I can pull it up here, but if you look at the transcript, the questioning started out, I think, as perfectly fair response to the defense's own questioning of that witness. Would you agree that to a point it was okay, but it took a turn?
So I would agree that to a point, talking about prior reports involving the family, that would have been okay. But it went beyond that. And it went to the point of talking about physical abuse allegations against Sean, that he had committed these things against his son. And I want to, on this point in particular, there's two things that I want to point to. I guess the purposes that the state says this evidence was admissible. On the one hand, under the invited error doctrine, the state says that it had to introduce this evidence of physical abuse against the son because otherwise the jury could have been misled to think that there were unsubstantiated reports of sexual abuse against the daughter. And that just does not hold up. When you look at the record and the evidence and the testimony that came in that the state says invited this testimony about physical abuse allegations, this is the testimony. This is at page 133 of day 2. There were reports on the family, none concerning the daughter as being a victim. Just minutes before that, on the previous page 132, this exchange happened. Question, and this is defense counsel asking these questions. Question, were you aware of any previous reports of sexual abuse in the home? Answer, no, not of previous sexual abuse. So this could not be more clear. There were no previous reports of sexual abuse in this family's home, and the previous reports did not concern the daughter as being the victim.
But then the defense counsel kept asking questions. And I mean, if the questioning had stopped there, you'd have a much better argument, wouldn't you agree?
The defense counsel was laying the foundation, Your Honor, to to essentially to get in the key piece of evidence for the defense, which was that the daughter had previously denied sexual abuse when specifically asked during a prior investigation. And it should have stopped there. In fact,
But why wasn't that question asked? I mean, that would have really been, it seems the foundation laid here was a very large foundation that allows for expansion in the future. If the question had been just as you stated it, that would have been straight to the point and allowed very little further development. But here, defense counsel then says, when you began your investigation, did you look at prior reports? Yes, and then continues. So at some point, the prosecutor's entitled to follow up on some of that, right?
Your Honor, we do not disagree that the issue of prior reports is fair game. Obviously, the defense counsel brought that up. But the fact that these were allegations of physical abuse against the son, really, there's no reason for that. And when you look at, on the flip side, when you look at the Rule 404B cases, there's something that I wanted to be sure to point out today. And this comes from State v. Coghill, which is a case that's not in our briefs, but it's from this court. It's 216 Arizona 578. And it talks about other acts evidence. And it talks about, there's two quotes that and ideas that I wanted to make sure to get before you today. The first is from paragraph 19 in Coghill. And that says, in the context of Rule 404B, Arizona courts have emphasized the importance of the trial court's role in removing unnecessary inflammatory detail. There, the court talks about Salazar, which reversed a conviction based on the admission of other acts evidence and said that other acts evidence can be sanitized or limited. That's like the cases that the state cites in its brief, Roscoe and Lee, where they talk about another murder but not connecting it to the defendant, or that unrelated matters. And so it's sanitized. And then in paragraph 21 in Coghill, the court said, this court has also reversed a defendant's conviction when the state elicited arguably probative other act evidence when ample non-prejudicial evidence had already been admitted for the same purpose. And there the court talks about Ballantyne. There the court said, it's not necessary to introduce evidence that the defendant was a Hell's Angel to show that he was familiar with how to work his motorcycle, because there was plenty of other evidence to that effect. So bringing it back to the two purposes that the state says why this was necessary, why this evidence was necessary and relevant. One, the jury, under the invited error doctrine, the jury could not have been misled to think there were unsubstantiated reports of sexual abuse.
Well, but the jury was left with the defense questioning, wondering what these reports were. And there was no reason for them ever to come into the trial except that the defense asked about them. So is the identity of the victim fair game? I mean, wouldn't the jury rightly be concerned with whether the victim was the same victim in this case or a different victim?
The jury could be concerned about many things, Your Honor, but that doesn't mean that they get to have that information.
Well, but as a general proposition, I take that as true, but I don't think that really responds to my question. If we break it down as to what was disclosed here, we're fine with the defense questioning, of course. And then when the cross-examination begins and the prosecutor asks that you looked at reports that didn't specifically mention this victim, is that a fair question?
Again,
or is the jury supposed to be sort of led into the wrong inference that all of these reports concerned a single victim?
Well, no, Your Honor, because the testimony that Ms. Demke, the DCS worker, gave said that the reports did not involve this daughter as being a victim and did not involve allegations of sexual abuse. And it should have ended there. That was enough information for the jury to have in this instance It did not need to know that Sean had been accused, and by the way, those allegations were not proven, certainly not proven by clear and convincing evidence, that he had been accused of physically abusing his son. And this is really going to the heart of Rule 404B. If a person keeps getting accused of abuse, he must be an abuser. And 404B does not allow that. The invited error doctrine, when you look at that, and I'm going back and forth a little between invited error and the Rule 404B, but that doctrine, it says that the one party can introduce evidence that if evidence introduced by the other party requires the other party to respond so the jury won't be misled or confused.
We've spent a lot of time on this point, and I
Yeah.
don't want to detain you further,
Sure.
but it is important. And so I need to ask us, let's assume that you persuade us with all these arguments that there was error. We still need to get to the question of whether it was prejudicial on this record. And that's where I think you should focus at least a minute.
Yes, sure, Your Honor. Again, here we have an accusation and a denial. This was an accusation of long-term sexual abuse. When you look at the testimony of the daughter, it was really, as we say in our briefing, painstakingly elicited. And so really you have a credibility contest. And the cases that talk about credibility contests talk about the evidence in this case was far from strong. And Anthony really is probably the best case for this, saying, it's the state's burden here to prove beyond a reasonable doubt that this was not harmful. Because the defense objected multiple times, this is the harmless error standard, and it's the state's burden to prove beyond a reasonable doubt. And there can be no proof of that here because the evidence was not strong.
Well, the evidence here that you're complaining about is also not terribly strong, right? I mean, he's on trial for sort of systematic abuse, sexual abuse of a female child, and then there is a mention over the course of 3 or 4 questions that he may have physically abused a different male child. How does that support an inference that he was a sexual abuser? A lot of people are violent without being sexually abusive.
Sure, and the nature of the allegations is not necessarily relevant. If there were another different type of other act evidence introduced, I think we would be facing this kind of the same question. It's not about.
So you'd be making the same argument if they said, were there reports of tax fraud?
Not necessarily, because this is directly about abuse of his children. Again, a person keeps getting accused of abuse.
Well, what about, isn't it true you got in a fight in a bar last year and you were convicted of assault? Would that have the same sting as this?
So that's a good question. I get your point, but that wouldn't be relevant here. It wouldn't have come in because it's not connected to these previous reports.
True. Well, just like the abuse, to accept your argument, the abuse shouldn't have come in. But I think what we're struggling with is how is the error not harmless, though? I mean, because we see, time and time again, you'll read legions of cases that to talk about, but it's error, but the error is harmless. We're not going to reverse on that basis. And so and I know I've read State versus Anthony many times, and we're very familiar with that, but it's a great case for teaching us the principle. We have to apply that principle here and make our best assessment of why it would not be harmless.
And to pile onto that, we also have a constitutional provision that cautions us against technical reversals.
And I would submit, Your Honors, that there are very few cases where 404B evidence has come in wrongfully, and the harmless error standard is applied, and the court finds that harmless. That is just because Terrazas, Anthony's, etc. down the line talk about this type of evidence intrinsically has the potential to to tip the scales against the defendant, and the defendant deserves that protection. And I'll reserve the rest for rebuttal, if I may.
Good morning, Michael O'Toole on behalf of the state. Below, the prosecutor, when this was objected to, made a pretty impassioned argument that this was invited error because the defense opened the door. That is not immediately apparent from the questioning itself, but if you look at the context of the questioning, I agree with the prosecutor below. First of all, you have this defense counsel asking prior witnesses if the victim was familiar with this DCS worker, Tammy Demke, and the answer was yes. Then you get to the questioning of Ms. Demke herself, who was called by the defense. And she, kind of consistent with her role in this case, states that when she first met the victim was in regard to these incident allegations. Then he asked, were you aware of any prior reports of sexual abuse in the home? No, not of previous sexual abuse. So at that point, the defense counsel is on notice that this woman has no information about the one prior incident where the stepmother alerted the authorities and the victim was questioned about allegations of sexual abuse. So it's clear that she was not involved with that. And if you look below in the record, there's various motions for depositions and whatnot for various DCS workers. This witness, Ms. Demke, was not on that list. It's unclear whether defense counsel ever had an interview with her. It does not appear that he did so. If he would have had that interview, he would have realized the only involvement with that she had was with the prior allegations of physical abuse of the son. So at this point, when she says, no, not of sexual abuse, should have stopped right there. But he goes on, and after a few questions later, when you began your investigation, did you look at prior reports in the state database? Yes. There were prior reports on the family, none concerning Abigail as being a victim. Now, that can be viewed two different ways, and the prosecutor viewed it a way, I think, that's not immediately apparent, but makes sense from the record. The most immediate, the way I read it initially, was that, well, there were prior reports on the family. There's only her and her brother, so we have prior reports on the brother. And if you look back to the last question, were there any prior reports of sexual abuse in the home? Then you have no. So you have the brother and you have some kind of other report regarding the brother. What's that left as? That's basically saying there was some kind of physical abuse of.
Well, that's assuming the jury bears in mind the same definition of family that you just advanced. I mean, families can be bigger, broader. I mean, who knows? I guess my question, though, is under what interpretation of the record is it appropriate to say that Alex was physically abused and that DCS took him from the home? Those are the 2 points that seem pretty indefensible as far as any door being opened.
Well, the fact that he was no longer living in the home was relevant because it went to the victim's credibility. She said that she was afraid for both her and her brother, more so for her brother, so she eventually did disclose when the brother left the home. As far as the physical abuse goes, I think the prosecutor was clearing up that question because when we have the answer, there was prior reports on the family, none concerning Abigail as being a victim. And this is the prosecutor below's interpretation, which is not immediately apparent. And that is this, that by saying she was not a victim, that's saying that there was reports, but they were unsubstantiated. So now we're talking about reports plural, and she's not being a victim. So that suggests those reports were unfounded sexual abuse. That's one interpretation of the record. And that's what the prosecutor argued below. The trial court looked at this, heard both parties, and said that this was something that the prosecution objected to in the first instance. I know he did get the name wrong, but because when they were hearing this issue initially before trial, the person with the information concerning the other person with the information concerning the abuse of the brother was someone named Buchanan. And so the state's saying, well, we don't want to have this brought up, and they didn't. So they didn't want this stuff brought up through anyone, and when it came up through this witness, they're just clarifying it. It was not prior reports of sexual abuse by the victim. The trial court was there, they heard everything, and basically said this was a natural consequence of how things proceeded at trial. So the trial court, who was in the best position, it found that the door was open. And I'll move on to why this is not prejudicial for the, both for any harmless error argument and for the denial of a mistrial. Again, you know, the court's in the best position to look at the evidence. Opposing counsel here is talking about a prior case where the evidence was sanitized. Here we have basically very sanitized evidence. There were allegations, no actual evidence of physical abuse. And they basically made clear that allegations is a very low standard because we want to protect the children. So,
But counsel, the allegation has to be read in context with, and is it DCS that took him from the home? I mean,
right. And
most people,
correct, but
to take
DCS,
judicial notice that most people know in this day and age that DCS removes kids from the home when there's parents that have not been taking care of the kids.
well, but
been abusive.
the work Ms. Dempke said, they basically err on the safe side, and we want to protect children. So they're not saying the allegations are true. They're just saying they're allegations. So we don't have, you know, actually he broke his arm or slapped him around or hit him with a bat or anything like that. It's very sanitized as far as being very bland.
It is relatively sanitized, but I suspect that the state knew that this shouldn't come in, which is why it didn't offer the evidence. I mean, this was a reactive line of questioning, right?
Correct.
And my guess is that you would prefer to have received this case without these questions in the transcript. Would you encourage us to write a decision that says admitting this kind of testimony in this context is just fine?
I would say under the facts of this particular case, it is hard because you don't get the indentations from the trial record. I mean, we weren't there. I mean, this worker initially was talking about investigation and doing reports and the level of proof, and then at the end says that there were no prior reports with her being the victim. So depending on how she said that, that could have been, it was perceived by the trial prosecutor in a way that basically suggested that's what she was suggesting.
I understand the dynamics of trial, but I'm trying to understand your position. Are you saying that this is harmless error, or are you saying that it's perfectly acceptable trial management under the rules of evidence?
I'm saying the trial court did not abuse its discretion when it basically agreed with the trial prosecutor that the defense, who called this witness and started asking about prior reports and suggestions to the jurors that there was more going on than
What if
it
the
was.
prosecutor had asked more questions about the abuse of Alex? Would that have been an abuse of discretion?
I probably would have, because the prosecutor was just clearing up the fact that these
So if the
prior reports.
prosecutor cleared it up by asking about some of the more gory details of the abuse, in your view, that would have been okay?
No, I didn't say that.
So I'm just trying to see where you think the line is. It sounds like you think that the trial judge walked right up to the line but not over it, or was there still some room for the prosecutor to keep questioning?
You know, I don't want to get into too many hypotheticals here because
Well, that's kind of what we do here.
it is when you announce a rule of law, but we have an open a door concept, which is basically fact specific for every case. So I can't imagine this kind of ever happening again. You know, when you basically.
I don't know, maybe my imagination is running wild, but I imagine this happening a couple times a month in our world. I mean, we look at harmless error quite frequently. And you know, will this exact transcript be recreated? No, but this pattern, this phenomenon does occur. And it strikes me that we would have a tough time saying that this line of questioning is the type that we endorse and that should be repeated. I don't know if you're arguing for that, though. And I don't know that you need to. I
don't think I need to. I'm not, but I'm defending the trial court's ruling here.
Counsel, let's go back to, assume for argument's sake that we believe this was error. Help me understand why the state has met its burden here of showing the error is harmless under the Anthony standard. I mean, beyond a reasonable doubt, that where we can say beyond a reasonable doubt, this error did not contribute to this verdict. When you don't have any physical evidence, you got the text. I agree, but you don't have the DNA that sort of, and those types of where you could say, oh, the evidence was overwhelming. There's DNA, there's X, Y, and Z. How do we line that up in writing the decision as an affirm?
Well, first of all, as discussed briefly, the evidence was very sanitized. It was very short. It was very clear too what the prosecutor was doing when he questioned the on cross. He basically cleared it up and he moved on. Later on, we have a juror question saying, why was Alex living with Dawn, the stepmother? So at least one juror didn't pay much attention to this evidence in the first place. So it appears that it just had its purpose of clearing up that there was no other reports involving the victim and sexual allegations. Again, these were just allegations. The CPS worker basically said that's a low standard. We want to protect children. They want to err on the safe side. There was no, defendant himself testified. There was no questions by defense counsel, by the prosecutor, or by the jury when he testified about his son in that regard. And frankly, the defendant himself said that he had been previously accused of neglect and abuse as being an absentee father when he was younger. The evidence of the physical abuse, or the allegations of physical abuse, were also tempered somewhat by evidence from the victim herself that the defendant was, aside from this horrific behavior of sexual molestation, was a good father. It was also tempered somewhat by the fact that the brother still visited the father after he was removed from the home.
Counsel, do you recall whether did the prosecutor build on this abuse of the brother in closing, or did you?
In closing, he basically pointed out that brother was no longer in the home when the victim disclosed, and basically said that's when she felt safe disclosing, safe for her brother to disclose and protect him.
But to your knowledge, it didn't touch the abuse of the
and frankly, the defense in closing too mentioned the brother was out of the house and questioned, well, the brother's out of the house, how come this is not escalating, and how come it's not more frequent, or something to that effect. I think as Judge Swan suggested, it's hard for the jurors, I think, to go from this act that is really irrelevant and basically use that as a way to find him guilty of this sexual abuse in light of the other evidence, including the text message, which is hard to read as being innocuous. And it's I think so damning that the defendant at trial kind of tried to distance himself from it by claiming, well, I don't remember that, or just didn't want to embrace it. Certainly. There's other cases where much more egregious other acts have come in. The courts have found it harmless. The jury instructions, the jurors were giving a 404B instruction, telling them not to use evidence of other acts that to find him guilty of the instant offense. And of course, they're presumed to follow their instructions. And probably, I guess, maybe the biggest reason why it's harmless is because that when we're done with the defense counsel's questioning, we're left with the following. Did you look at prior reports? Yes. Were there prior reports regarding the victim? Yeah. Well, there were prior reports on the family, none concerning the victim. And this is by the defense. So we already have information that's just as damning or pretty much. So it's kind of cumulative what came in next from the prosecutor.
Well, I think the argument, and I'll ask both sides about this, but the argument is probably best phrased as the real sting was the prior contacts with DCS, and the best way to bolster the defendant's credibility would have been to somehow suggest that DCS just came on the scene recently. And I think you're saying that means there's no prejudice, but you sound like you might also be asking or asserting that this line of questioning could have gone much further, that the door was open that much wider.
No,
that's where I'm having.
Your Honor, I'd never suggested that once. I basically am just defending the trial court's ruling.
I may be mishearing you then.
Yeah, I'm just defending the trial court's ruling. I think the trial court was there. It heard all the evidence, and it basically found this was a natural consequence of the trial, and something the prosecutor did not want to initially get into, but it became relevant because of the defense question. But as far as the harmless error goes, before the prosecutor gets involved at all, we have the fact that there were prior reports on the family. They were not sexual abuse reports, and the victim was not the victim. So necessarily, of course, family can mean anything, but in the context of this case, it means, I think, the father, the son, and the daughter. So by process of elimination, we have, before the prosecutor gets involved in questioning, we have reports of abuse of some sort against the son. So for all those reasons, the state believes that there was error, it was harmless. I can't see my time. I'd like to briefly talk. 5.5 minutes, yeah. I'd like to briefly talk about the sentencing issue. In In the reply brief, opposing counsel cites, I'm not sure how to pronounce it, Vermeulen. We would have briefed this if it had been addressed in the opening brief. The state believes Vermeulen is wrongly decided. Their Division 2 basically said the sentencing issue was reviewed for abuse of discretion because there was, the defendant didn't have a chance to object. But I don't know what prevented the defendant from objecting either directly in that case. I know it's a solemn proceeding, but you can wait till the trial court's done and point out any errors you believe occurred. And if not, you can always file a Rule 24.3 motion to modify sentence.
But sentencing error, I mean, this has always troubled me in some of the decisions that come out of our appellate courts. We go through this long explanation of how to get to fundamental error and then conclude with the proposition that sentencing error is always fundamental anyway.
No,
So I think we sometimes waste some words in our decisions, but at the end of the day,
Well-
don't we have to review this?
well, you have to review it, sure, but for fundamental error. And
Well, but doesn't that fundamental error review just sort of collapse into a simple legal error because sentencing error is always fundamental?
No, Your Honor. In Henderson, for example, there was sentencing error, and the court went through a very, fact-specific analysis and found that in that case, it was fundamental error. There's numerous cases from this court and the Supreme Court basically finding that the alleged error is not fundamental error. I agree in some cases, like for example, the 13-116 issue, that's going to be fundamental error always, right? That's a legal thing. And
Right, or precedence incarceration credit.
Correct, right. So there are certain categories that, yeah, we do say it's fundamental error, then we just move on to the error. But this is not that case. This is a case where the sentencing judge's statement can be looked at two different ways. The state looks at it one way, opposing counsel looks at it the other way. But we believe that the court was basically just expressing it. It could have used better language. I think what the court was saying, because these offenses were different dates and involved different actions, justice mandates that they be consecutive. No one was saying that there's a statute basically saying these had to be consecutive. So at that point, if defense counsel would have said, Your Honor, and actually even before the court pronounced the actual sentence, the court made that statement. So at that point, before sentence is announced, the defense counsel could have objected.
Well, it does say, I do believe the law mandates that I have to go between these numbers and I have to run these charges consecutively.
Right.
Now, if the trial judge had concluded that consecutive sentences were in the interest of justice, I don't think there's any argument about it. But when the trial court doesn't seem to believe it has the discretion to consider that, wouldn't we want to give the trial court that chance?
I think that sentence can be read two ways, and I read it basically saying the law mandates that I go between these two numbers, and I have to impose consecutive sentences. But when the court imposes a consecutive sentence, it basically explains why it's doing it. So it can be read two different ways. And I think at this point, since it's the defendant's burden, that it has not met its burden. The court cited all the relevant sentencing statutes. None of them required consecutive sentences for that last offense. Defense counsel asked for a concurrent sentence. The trial court did not say that's wrong, you can't be concurrent. The prosecutor did not object to the defense counsel's statement that a concurrent sentence was available. The prosecutor's request for consecutive sentences was not based on any statutory scheme, but instead was based on the fact that these were separate offenses at separate times. So for all those reasons, we believe that the defendant has not met his burden.
Okay, thank you, counsel.
Thank you, Your Honors. I'd like to go back to the question about prejudice, and I'll give you my best bullet point list of why this error was harmful. This other act's evidence was harmful. First, as mentioned before, the daughter was the only evidence against Sean, her testimony. The juror question, CR190513, we have a very different reading of this juror question. It came during deliberations. It shows that the jurors were thinking about, why is the son no longer in the home? Why is the son not testifying? They're focused on what is going on there in this home. Again, Anthony talks about no limiting instruction. It's still, there was a limiting instruction there. It is still a harmful error. Here, there was no limiting instruction at all. In addition, The fact that these allegations were not proved by clear and convincing evidence and could not have been proved by clear and convincing evidence because it was an allegation. Aguilar, which is a case that we cite in our briefs, and that was a 404C case, but in that case, the Supreme Court concluded that it was impossible to find this error harmless because the allegation was not proved by clear and convincing evidence. And then finally, or penultimately, the prosecutor did come back to this point in his closing argument by mentioning that the son was removed from the home. And so taken together, this evidence would, again, allow the jury to think that he was a bad parent, a chronic abuser, and a monster, and hold that against him and find him guilty, not because of the proof, which was slim, but because they thought he was a bad person, a bad parent.
Okay, well, let me then ask you, isn't the real sting of all this that DCS had been involved in the family's life? I mean, once you acknowledge that, you are really on a slippery slope to all the inferences of bad parenting that you mentioned. And that was elicited by defense counsel. So while I might agree with you that this went too far, it seems that the fundamental prejudice, if any, resulted from defense counsel's own questioning.
I disagree with that. People,
I'm not surprised, but feel free to tell me why.
People are accused of things all the time, and that's what happened here. There was an accusation, and DCS is required to get involved, and I think that came out in the testimony.
So what's wrong with the testimony that came out then? Just that Alex left the home?
Well, that we don't disagree. That evidence was fine. But the fact that Sean is accused of physically abusing, beating his son.
Well, he didn't say beating, it just said physical abuse. So are we down now to this whole argument turning on one adjective, physical? Because the evidence that DCS was involved came out through your predecessor counsel, right?
That is correct.
Okay. And the evidence that Alex was removed or left the home came out, and you don't seem to think that's a huge deal. So all we're left with, the only arguably inappropriate sting here is the word physical.
Well, I disagree.
I mean, what other?
Well, physical abuse.
I mean, if the jury hadn't heard the word physical and had thought it was emotional abuse, would that have somehow exculpated your client?
Well, I think it's the combination of abuse, regardless of the kind of abuse, really, and the combination that abuse led the government to remove this child from the home. And so it's both of those together. The fact that he was no longer in the home is one thing. Again, it's limited, sanitized. The fact that DCS was involved, well, that's just allegations. But the fact that this other child was abused, and the accusation against the defendant who is on trial, and that is the sting. It's those things together. As you said earlier, Your Honor, the family could mean a lot of things, and there was testimony about other family members in this case. So we don't know. The jury didn't know who were the allegations against, who were the allegations about. But
that. I tend to agree with that, but be careful with that argument, because doesn't it work against you? I mean, doesn't that underscore the need to clarify this a bit?
No, Your Honor, there's no need to clarify. What the jury needs to know is that there were prior reports on the family. They don't need to know anything about the son, abuse against the son, or in fact, that it was the defendant who was accused of abusing him. That's really the sting, I think, that didn't come out at all in the defense questioning.
Than the bare word abuse, I don't think they did learn anything else about it.
Well, physical abuse against the son, and that it led to his removal from the home, which suggests more serious.
Okay.
Okay, counsel. Thank you both. Your time is up,
you.
but thank you both for your helpful arguments this morning. The court will take this matter under
May I make a comment?
Oh, yes.
I would just say it's rare that we have oral arguments in criminal appeals in this court.
Yeah.
I've probably sat on fewer than 10, and I'm one of the more senior people here. So I appreciate the fact that you've come in and asked for it. I think it's a healthy thing for the system.
Thank you, Your Honor.
Take it under advisement and issue a decision in due course. Thank you.